The gentlewoman for Richmond City, Ms. McClellan.
Thank you, Mr. Speaker. Point of personal privilege.
The woman has floor.
Thank you, Mr. Speaker. In October of 1900, Archer Allen Flagler was appointed to the Supreme Court of Virginia by Governor Tyler to fill a seat left vacant by the death of a justice. Justice Flagler remained on the bench only a few months, as the 1901 General Assembly decided not to confirm his appointment and chose to elect Stafford Gorman Whittle instead. 114 years ago is the last time the General Assembly has refused to elect a justice appointed by the governor. 114 years ago. That is not a streak we should break today. In this body, we talk about the value of precedent. We talk about the value of tradition. And yes, we have our partisan squabbles and territorial fights, but we should not let them get in the way of affirming an eminently qualified justice to the state's highest court. We should think very hard about the precedent that could be set today if we remove Justice Roush from the court. We will be saying that the power outlined in the Constitution of Virginia of a governor to make an interim judicial appointment when the legislature is not in session is not really a power at all. We're saying it's an empty thing, something not worthy of our respect. We will be telling all future judges that if they accept an interim appointment from a future governor, thereby giving up the security of a job that they've had, they'll be giving it up for something ephemeral. We are saying to those future governors that even when they make fair choices, good choices, and appoint judges recommended to them by the bar and even members of the other party, we will not respect that. We are saying that we will make political choices instead, that we will choose partisanship over precedent and politics over process. Now, there was a process here. The governor publicly announced that he was seeking applications for this vacancy on the Supreme Court, asking for recommendations. And this process went on for about 6 weeks. It was no secret. There were no objections or questions raised until after that process was finished and Justice Roush was sworn in. The only question here should be whether Justice Roush is a good and qualified judge. And no one in this body or down the hall or anywhere has argued that she is not. She is very qualified. And her qualifications and her career should not be thrown out on a political whim. 114 years. In that time, other governors have made interim judicial appointments, including to the Supreme Court and the Court of Appeals. And the General Assembly has elected those justices to full terms. Governors Kane and Warner made interim appointments like this, and their appointees were treated with the respect they deserved, interviewed, certified, and elected. It is indeed a question of respect. Respect for precedent, respect for the process, respect for the judiciary, for the Supreme Court, and respect for Justice Roush. Thank you.